Sit back and observe the play. You have done all your preparation work. Stay alert, but do not participate if there is an appointed public defender. Let him be your mouthpiece. Do not hire an attorney though if they do not appoint a public defender. You may have to participate enough to get your third-party witnesses as to the agreement of the parties and your status as the creditor on the record. Don't screw it up by dishonoring your own status as the creditor on the cases. They will try everything to get you to testify. Argue. Call witnesses, file an answer. Explain your private process. Dishonor the judge. Dishonor the prosecutor. Dishonor your lawyer. Join the commercial process. Hire an attorney. You can ask their witnesses questions about the certificates issued by the notary. Did you respond to my notice of acceptance and request for confirmation? Did you send me a copy of a notice of dishonor from a qualified third party? Did you cure your breach? If there is a problem with the judge or the other actors accepting your acceptance, there is always a wonderful question to ask. Your Honor, will your bond withstand the commercial liability of the charges this court is entering today? Do not participate in the courtroom drama. The court-appointed public defender speaks for the defendant. If there is no public defender, you can make your own points, but you are limited to very few issues. There is no controversy. You want settlement and closure. You have accepted the judge's oath and have a contract with him. You have bonded the case. You do not do any of the things listed above. There is a public defender, he is the only one who can speak from your side of the courtroom. As long as there is a defense attorney, the judge cannot see you or hear you. If you try to talk out of frustration or for clarification, you will lose your position as creditor. Debtors testify, argue, call witnesses, file errors, and dishonor. You are not a debtor. When the judge asks how the defendant pleads, it is your counselor who will answer. His answer LD be that he has a statement to read into the record. That statement should be your letter to the counselor. Everything in your letter to the counselor is designed to have him act in his capacity as a lawyer for his client while he protects your private interests and negotiates closure and settlement for you. He is not permitted to defend the defendant, the straw man. He is not permitted to argue any of the facts. He is not permitted to engage in any controversy at all regarding this case. His job is to be your mouthpiece in the proceeding. He is an officer of the court and has capacity to speak in that court. If there is a public defendant, you never speak in court. If you do, you will negate the relationship you have with him by dishonoring him. You will not be acting like a creditor. You will be acting as though he is incompetent to represent your creditor position and bring closure to the case. Remember rule number 2. Stay in honor. You are authorizing the counselor to negotiate the settlement for you. Stay out of his way so he can do that. Keep your mouth shut in court. You are not going to testify ever. Debtors testify, debtors defend themselves. Debtors dishonor. The term might be that the straw man pleads guilty. This is for the public show. It should be problem for you to enter a plea of guilty to the facts for the defendant. You are not disputing the facts. It should be a problem for the defendant to plead guilty to the charges. Once you have the appearance bond, and upon the issuance of the APPERANCE bond, the lawyer can enter a plea of guilty for the defendant because your exemption is bonding the whole case. When you accepted and returned the presentment, and attached an instrument to discharge all the charges, and sent your letter of credit to the secretary, and gave notice to the public that you had accepted the presentment, you became the creditor in the case. The first time you are in court, the lawyer will read the lawyer letter into the record. The lawyer will almost always say he cannot or will not read the letter in court. He will whine and imply that you are silly and maybe even stupid, but he will read the letter, because the judge knows he has it and has been instructed to read it. He knows this because you asked him to file it with the clerk in the file. If he does not have it in the clerk's file before the hearing, you can put it in there on your way into the hearing. Get a certified copy of it to show him when you sit down next to him at the defendant's table in the courtroom. Also, be prepared to give him cues as to what you want him to do. You might want to prepare cards with large font messages for him to read if he gets off track and away from your instructions. Do not argue any of the facts. Enter the judge's oath into the evidence file. Read my letter into the record. Enter mu bond into the evidence file. We are here for settlement. Go for closure. Ask judge to discharge the bond. There is no controversy. Do not call any witnesses. Do not cross-examine except regarding the notary's certificate administrative process, certificate sample #A. Certificate of non-response. Re. Acceptance by John Henry Doe of complaint on case number 12121212 John H. Doe Susan Smith, and the notary who verified Dave Brown's dishonor of John Henry Doe's notice of acceptance, for John H. Doe, pursuant to state law regarding evidence of dishonor OCGA Section the 11th of March 505 and Section the 11th of January 202. I certify the following. Blank. The record shows I mailed a notice of breach to Dave Brown at ABC Agency at address by certified mail package #cert#RR, as verified by certificate of service. After acceptance of both mailings, Dave Brown, for ABC Agency, refused to send the confirmation that the account for case number 121,212,212 has been adjusted and settled, nor a notice of dishonor from a qualified third party excusing his refusal, in the 10 days following the second mailing. Dave Brown, for ABC Agency, did not cure his dishonor. He gave no reason for his refusal to confirm the adjustment and settlement of the account or send a notice of dishonor. Therefore, based on the foregoing facts, I certify that Dave Brown, for ABC Agency, dishonored John Henry Doe and me through his non-response, and did thereby agree that John Henry Doe accepted the subject complaint for case number 12,121,212, returned the complaint, exchanged his exemption for the discharge of the associated charges, presented an authorization for the use of his credit to set off all associated court charges, included processing instructions, included a statement of account showing a zero balance. Sent a letter of credit to Timothy Geithner as notice that exemption number 123,456,789 was being used to settle account number 12,121,212. Further, Dave Brown agreed that his refusal to send the written confirmation of the settlement of account number 12,121,212, or notice of dishonor from a qualified third party, in no way negates the fact that said account settled and closed, that he and the agency he represents have no capacity to pursue collection on said account, and that further pursuit of collection is agreement that Dave Brown and ABC Agency collectively and severably owe John H. Doe $5,000 for expenses of handling Dave Brown's presentment, and that John H. Doe may take all necessary steps to secure its claim to the debt owed to it and to collect. Dated, blank, seal, blank, underscore, blank, Notary Public. Stamp. Susan Smith. Notary Public. Address. Address. 9898 void where prohibited by law. Admin process, notice of acceptance sample #A2. Certified mail number 9898 RR. Mailed by Susan Smith, Notary Public. Address. Address. 2. Dave Brown. Notice to agent is notice to principal at ABC Agency. Notice to principal is notice to agent. Address. Address. Date, blank. Re. Complaint on case 12,121,212 John H. Doe. Notice of acceptance. Please be advised that I have accepted your presentment to John H. Doe for assessed value and am returning it to you in exchange for closure and settlement to account number 12,121,212. Please send the confirmation that the account for case number 12,121,212 has been adjusted and settled, to the address shown above, or send a notice of dishonor from a qualified third party. I am also enclosing an authorization for you to facilitate the use of my credit to discharge all court charges that may apply. The instructions and statement of account are attached for your convenience. John Snow is also being notified that I have using my credit for this purpose. Your refusal to send the confirmation or notice of dishonor will in no way negate this settlement, and will be your agreement that you and your agency have no capacity to pursue collection. Further collection efforts confirm your agreement that you and your agency, collectively and severably owe John H. Doe $5,000, and that John H. Doe may take all necessary steps to secure its claim to the debt owed to it and to collect. Thank you for your immediate attention to this matter. Sincerely. Blank, underscore. Number 9898 John Henry Doe. Admin process, Certificate of Service sample #A3. Certificate of Service. On, blank, I mailed to Name of respondent. Address. Address. The papers identified as 1. Notice of acceptance. 2. Accepted presentment. By mailing them in a prepaid envelope, addressed to the recipient named above, bearing certified mail number 9898, return receipt requested. Dated, blank, blank, underscore, blank, blank, underscore, blank, Notary Public. My commission expires. Susan Smith, Notary Public. Notary's address. Notary's address, seal. Admin process, notice of non-response sample #A4. Mailed by Susan Smith, Notary Public. Certified mail number 9898 RR. Address. Address. 2. Dave Brown. Notice to agent is notice to principal at ABC Agency. Notice to principal is notice to agent. Address. Address. Date, blank. Re. Complaint on case number 121212112 John H. Doe. On blank, I sent you a notice of acceptance and a request that you send confirmation that the account for case number 12,121,212 has been adjusted and settled, or send a notice of dishonor from a qualified third party. It was sent by certified mail blank, 9899, return receipt requested with a certificate of service. In the event your dishonor through non-performance and non-response was unintentional or due to reasonable neglect or impossibility, I am attaching a copy of the same presentment to this notice of non-response. Please send confirmation that the account for case number 12,121,212 has been adjusted and settled to the address shown above, or send a notice of dishonor from a qualified third party. If you have an excuse for not performing as requested, please mail your particular statement to me at the address noted above. Your specific performance or statement is expected no later than 10 days from the date this notice is postmarked. Thank you for your prompt attention to this matter. If you fail to cure the breach, your refusal will be your agreement to all statements made in the notice of acceptance. Seal. Blank, underscore, blank, Notary Public. Stamp. Number 9898. Court process, notice of acceptance to Judge sample #A5. Mailed by Susan Smith, Notary Public. Certified mail blank, RR. Address. Address. 2. Dave Brown. Notice to agent is notice to principal at ABC Agency. Notice to principal is notice to agent. Address. Address. Date, blank. Re. Complaint on case number 12,121,212 Plaintiff vs. John H. Doe. Dear Judge's name X. James Jones. Please take notice that I have accepted the presentment made by name of prosecuting attorney to John H. Doe for assess value and returned it to the presenter in exchange for closure and settlement of account number 12,121,212. I have exchanged my exemption for a discharge of the charges. I enclosed an authorization for him to use my credit to discharge all court charges that may apply. The instructions and a statement of account were attached. The Treasury has also been notified that I am using my credit for this purpose. I request an appearance bond at no cost to me so I can enter a plea for the defendant. I do not dispute any of the facts in the charging instrument. Based upon the issuance of the appearance bond and the absence of an assessment and findings of fact and conclusions of law, I will enter a plea for the defendant exchanging my exemption for full settlement of the account, both civil and criminal. I have requested that I be notified through the notary named above with the place, date, and time I should appear to receive the appearance bond. I expect that will also be when I will enter the plea for the defendant into the record. The opposing parties have previously reached an agreement on the issues in the complaint. There is no controversy. A copy of the relevant certificate is attached. I want settlement and closure of this account immediately. Sincerely. Blank, underscore 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 John Henry Doe. Number 9898. Court process, notice of the court clerk of acceptance and private process sample number 6. John Henry Doe. Contact address, Susan Smith, Notary Public. Address. Address. Name of court. State of, blank, case blank, plaintiff. Versus. Closing parenthesis. Notice of acceptance John Henry Doe, and defendant. Request for appearance bond. Blank, underscore 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 underscore. Please be advised it is my intent to expedite this process to reach settlement and closure on this accounting immediately. I have accepted complaint number 12,121,212 for value and returned it to Mr. Blank, who appears to be the charging party on behalf of the state of Arizona. I have exchanged my exemption number 123,456,789 for the discharge of the charges. I hereby request an appearance bond at no cost to me so I can enter a plea for the defendant. I do not dispute the facts. Based upon the issuance of the appearance bond and the absence of an assessment and findings of fact and conclusions of law, I will plead guilty to the charges and exchange my exemption for full settlement of the account, both civil and criminal. Please notify me at the address shown above with the place, date, and time I should appear to receive the appearance bond. I expect that will also be when I will enter the plea into the record. I have attached a copy of the certificate relevant to the existing agreement and copies of James Jones' oath of office and bond. I have retained the originals for introduction in open court. Submitted this, blank, underscore day of underscore, blank, 2012. Blank, name. CC. A copy of the foregoing was mailed on the blank, day of, blank, 2012 to blank, attorney for plaintiff. Blank, underscore 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 underscore. Blank, underscore 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 underscore. Court process, letter to counselor sample number 7 date, March 30, 12. Greta Jones, counselor. M. John Henry Doe. Case number 12,121,212 plaintiff versus John H. Doe. U.S. District Court, Southern District of some state. Dear Mrs. Jones, please take note that I am claiming an interest relating to the property which is the subject of this action in rem. I am so situated that the disposition of the action may as practical matter impair or impede my ability to protect that interest, which is not adequately represented by existing parties. I accept the kind order of the U.S. District Court, Southern District of some state on September 1902 by John Black to appoint you attorney for the defendant. I accept this offer for value and am returning it with this notice to you. I now request that you escrow your bar certificate during the course of this case, and serve as my counsel in the following manner and only in the following manner. As there is no controversy in this matter, I do not want you to argue any facts or public issues as they apply to the defendant. You are not authorized to foster an argument or to join an argument on my behalf or on behalf of the defendant. You are not authorized to defend the defendant. For you to stay in honor, I want you to enter the notice into the record by filing it with the clerk of court and by reading it into the record in open court. This is notice that I have accepted for value and returned all public offers associated with this matter, and notice that I have made every effort to reach settlement through exchange of my exemption for adjustment and set-off of the public charges against the defendant. Ask the judge to take mandatory judicial notice of the private agreement that has been reached through offer and acceptance. A copy of the relevant certificate is attached. I want you to get a copy of the bond that bonds the charges in this matter. If there is no bond in the file, I will provide my bond in its stead. Notice of acceptance of offer. Return of offer and instructions. 4. I want you to request an appearance bond at no cost to me so I can be released on my own recognizance. When the bond has been issued, I will enter a plea of guilty to the facts for the defendant. I will not dispute any of the facts in this matter, but I do not agree to be held personally liable with no protection. 5. After acquiring the appearance bond, I authorize you to use my exemption to bring the accounting on this matter to closure. Request that the prosecuting write a check to close the account and release the bond to the defendant. 6. If for some reason my request for an appearance bond is dishonored, I want you to give notice of my intent to accept John Brown's bond for value and to use it to bond the charges using his bond as surety. His signature is the only one on record as a responsible party. 7. If necessary, I also want you to give notice of my intent to accept John Brown's bond for value and to use it to charge a Chapter 7 involuntary liquidation and start discovery under 11 U.S.C. 1126b. If the dishonor is not cured within 72 hours, I want you to file the bankruptcy petition in the federal bankruptcy court naming the defendant as the debtor and John Brown as a delinquent creditor, along with others who have already or may dishonor me. You are authorized to distribute B10 proof of claim forms to the dish honoring parties, should there be any at the next hearing. This bankruptcy discovery process will locate my remedy and release it to me through liquidation of the delinquent creditor's assets. 8. In the event you, as my fiduciary, dishonor me by not following my instructions, I request that you file a mandatory judicial notice of your refusal with the court and file a written appearance in this case. Thank you for your understanding and cooperation. Blank, _, blank, John Henry Doe. Notice of appearance of offer. Return of offer and instructions bond the case sample number 8. John Henry Doe, address. Address. Superior Court in and for the county of, blank, or wherever. United States of America case number 0000000. V. Closing parenthesis. Bond John Henry Doe, there appearing no bond of record to initiate the matter regarding case number 0000000 and warrant number 0000000 if applicable, and associated accounts, I, John Doe Smith, undertake as follows, in consideration of the fact that no lawful money of account exists in circulation, and in consideration of the fact that I have suffered dishonor regarding the matter of case number 0000000 and warrant number 0000000 and associated accounts, I underwrite with my private exemption number 123,456,789. Any and all obligations of performance loss costs sustained by the United States of America, state of name of state, and the respectful citizens regarding said matter. Done at name of county, state this, blank, day of, blank, 2012. Blank, ______ John Henry Doe. Bond the case sample number 9 John Henry Doe. Susan Smith. Notary address. Notary address. United States District Court, City, State. John Henry Doe, amended complaint. Plaintiff Bill in Equity vs. Closing parenthesis. ABC Agency Case No. Blank. Defendant, blank, _, blank, _, blank, County, SS. State. Jurisdiction and venue. 1. Jurisdiction in this matter is hereby granted by John Henry Doe, authorized representative for John Henry Doe by way of sufficiency of pleadings, see affidavit in support of amended complaint bill in equity. 2. The venue of Thid Court is correct as John Henry Doe does business in the state of, blank, and John Henry Doe is diverse from ABC Agency, doing business in state of, blank, and the amount in controversy exceeds $75,000. Parties. 3. John Henry Doe has established a residency in state of, blank, for over 1 year. 4. ABC Agency demonstrates a residency in the jurisdiction of the United States and does business in state of, blank. Facts. 5. Plaintiff has exhausted administrative remedy and comes to this court of equity with clean hands and in good faith, see Exhibits A, B, C. 6. Plaintiff has established judgment in estoppel against defendant as evidenced by attached the certificate of non-response, certified by Susan Smith, a notary public for, blank, county, blank. 7. Plaintiff's administrative remedy is res judicata. 8. Failure of defendant to respond in this matter is stare decisis. 9. Plaintiff's administrative remedy is ripe for judicial review, and there are no facts in controversy. Legal claims. 10. Plaintiff is entitled to relief in this equitable claim. 11. Defendant is estopped for failure to respond to original administrative process. 12. Plaintiff has placed the facts and law before this honorable court. Relief sought. 13. Plaintiff requests judicial review of his administrative process and remedy. 14. Plaintiff requests this court to find the facts and execute on the law of the contract before this court. 15. Plaintiff requests summary judgment on his administrative remedy. 16. Plaintiff requests the court to order defendant to pay the sum certain $1,000. Over to plaintiff. 17. Plaintiff requests the court to release the order of the court to John Henry Doe. Respectfully submitted by order of John Henry Doe. Blank, _, blank, John Henry Doe, authorized representative of John Henry Doe. State. County. On this, blank, day of, blank, 2012, I, blank, a notary public for the county and state noted above, did upon proper identification by John Henry Doe received his oath sworn and subscribed, and did witness his signature on the foregoing. Blank, underscore, blank, blank, underscore 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 notary public my commission expires service. A copy of the foregoing was mailed by first class mail on this blank, day of, blank, 2012 to ABC Agency, address, Dave Brown, address. Creditors and their bonds. A4. 1. Bond supporting credit authorization. 2. Bond for discharge. 3. Appearance bond. 4. Surety bond. 5. Case bond. 6. Performance bond. Rules of the game. Rule number 1. The fiction and the real cannot mix. The public and the private cannot mix. Rule number 2. Stay in honor at all costs. Rule number 3. There is no money. Rule number 5. Dom not participate in public plays. I am not a math teacher. It all has to do with trusts. Here is an example of a typical court scenario when the man participates. Here is a different scenario when the man does not participate. Administrative process. Step 1. Visualize this first. You are in the courtroom on your case. Step 2. Prepare the certificate of non-response. Step 3. Prepare your notice of acceptance. Step 4. Prepare the notice of non-response for the notary. 4. Accept and return the court presentment. 5. Attach an asset, an authorization for the state to use your credit. 6. Letter of credit. 7. Get a certified copy of the judge's oath of office and accept it for value. 8. Get a certified copy of the judge's bond and accept it for value. 9. Give notice of your acceptance by a private mailing to the man or woman doing business as a judge. 10. File a notice of acceptance on the public side. Public defender. Hot potato game. 11. Get a copy of the court order appointing the attorney and accept it for value. 12. Prepare a letter of instructions to be mailed to the appointed defense attorney. 13. Check the clerk's file for a bond. 14. Prepare your bond to bond the case. 15. Remove the case, sit back and observe the play. Do not participate in the courtroom drama. That's it. We'll read again after your updates.